Justice and Correctional Services Department briefing Parliament on legislation to criminalise racism and hate speech. Let me take you live now to Cape Town. eNCA's Annika Larsen is reporting that for us this afternoon. Annika, good afternoon to you. Do we have an exact understanding of what criminalising hate speech would actually mean?
Well, that's a question a lot of committee members are asking, Jeremy, because we do have legislation under common law in place which allows for the prosecution of all kinds of speech, not just racial, but in terms of causing hurt via gender, sex or religion. And that is crimen injuria. You'll remember the Vicky Mumberg case in which she received rather unusually a custodial sentence for the hurt and harm that she caused those police officers trying to help her on the day that she was involved in that accident. So there has been some concern from lawmakers that this is perhaps a political rather than practical kind of decision to actually elevate this sort of crime. I think the question is, how do you quantify hurt and harm and the incitement of hatred?
And Annika, how then are supporters of this potential legislation approaching their argument to it? Why are they saying that it's necessary?
First of all, it elevates the crime. So, for instance, if you remember that terrible coffin assault where the men when the men put one of their farm workers in a coffin, instead of that just being assault with intent to do grievous bodily harm or attempted murder, it would also be then categorized as a form of a hate crime, and perhaps that would prevent, from a preventative sort of measure, stopping people from doing that kind of crime. You'd also be able to tabulate and work out how many hate crimes are being committed in the country at any one given time. At the moment, there's no way of telling because it falls under common law. So it's statutory law that Cabinet really is pushing to introduce. Committee members said they want to discuss it amongst themselves before putting it out for public comment, which I understand the Justice Minister Michael Masuta and the Deputy Justice Minister John Jeffrey weren't too happy about, because they wanted to go straight out for public comment.
What's the conventional wisdom here on this? Do you think it'll find reasonably easy passage?
I don't know. I think there's a big practical component, which is the magistrates' courts are overburdened and understaffed, as are the high courts. And as one MP said, you'll end up sending 60% of the population to court or to jail, depending on how you deal with this. What do you do if you have a person screaming at somebody outside an abortion clinic shouting sort of some form of hate speech that she's decided to terminate her unborn baby? Is that a form of hate speech? How do you deal with anti-religious groups, Muslim and perhaps Jewish groups, shouting at each other on any one given day in the corner shop, whatever? It's very hard to legislate, it's very hard to prosecute, and I think a lot of it depends on he said, she said, and I'm not quite convinced how you actually measure forms of hatred and incitement. On the other hand, it does have the deterrent factor. It means that South Africans need to take any kind of hate speech seriously. We're still brutalized from our past, and we need to make sure that those who are guilty of such crimes perhaps are held to account and made an example of.
I understand that today's meeting or gathering is confined to looking at a punitive approach as far as this problem is concerned, but surely members of Parliament would also have raised the issue that it's not just about punishment, it's also about a broader societal problem that we're dealing with increasingly in this country.
That's why I think the deterrent factor is probably important, although when you look at the punitive or the custodial sentence that was issued to Vicky Mumberg, she was found guilty on 4 counts of crimen injuria. The question was jail really going to act as a deterrent, and would that really help her change her mind about the way she sees black people? Or would it just actually make her behave in an even worse manner? So I think it's really about weighing up whether custodial sentence is appropriate appropriate. And I think it's very much about taking each case on an individual basis, along with the magistrate or a judge who's hearing the matter, which, as you know, it's very difficult for them always to be impartial, because we saw, for instance, in the Ashwin-Willemse case, so many people felt a Me Too moment there, and you'd have to stick very strictly to the prescripts of the law. So perhaps there'd be some kind of minimum sentencing requirement.
All right.